Hello. The topic for today's discussion is remoteness of damage. Now, what is remoteness of damage? We will understand it in the course of the lecture. But after understanding what is a tort, who can be liable, the capacity to sue, be sued, we have to understand to what extent is somebody liable. Is somebody liable for all the acts which continue after the tort has been committed, or is there some stop to the extent of liability? So, this is what remoteness of damage deals with. The problem of remoteness. After the commission of a tort, the question of defendant's liability arises. That is, once you've committed a tort, the question arises to what extent can you be held liable, or to what extent is somebody liable? The consequences of a wrongful act may be endless, or they may be consequences of consequences. So, one act leading to another, like dominoes fall, one after the other, everybody falls. That can also be a consequences. One effect leads to the other. So, will the defendant be liable for all the acts which happen? This is what we are going to discuss, the extent of liability of the defendant. And why do we talk of the problem of remoteness? Are you liable for the remotest damage also? This is what we will study. For example, a cyclist negligently hits a pedestrian who was carrying a bomb in his pocket. Now, a cyclist hits a pedestrian and the person was carrying a bomb in his pocket. When the pedestrian is knocked down, the bomb explodes. The pedestrian and 4 other persons going on the road die, and 20 other persons are severely injured. Further, a building nearby is engulfed in fire due to the same explosion, and some women and children are also severely injured. Now, the question is whether the cyclist will be liable for all the consequences or only for the fact that he hit the pedestrian and he fell. Is that the liability, or is he liable for the end result till the women and children? Okay, now he's only liable for the consequences which are not too remote from the conduct. It should not be too remote. If a building catches fire because of somebody's falling and a bomb exploding, the pedestrian could not have foreseen it. Correct? No defendant can be made liable ad infinitum, that is, for all the consequences which follow his wrongful act. On practical grounds, a line must be drawn somewhere, and certain kinds or types of losses through a direct result of the defendant's conduct may remain uncompensated. So, though there may be a direct result may remain uncompensated, but there has to be a line which is to be drawn. We will understand where and how that line is to be drawn. We'll also study the tests of remoteness. Now, Lord Wright has said, the law cannot take account of everything that follows a wrongful act, right? Everything that follows a wrongful act, nobody can take account of. In regard some subsequent matters as outside the scope of its selection, because it were infinite for law to judge the causes of cause or the consequences of consequences, because it is difficult for the law to understand the causes of causes, the consequences of consequences. In the varied web of affairs, the law must abstract some consequences as relevant, not perhaps on the ground of pure logic, but simply for practical reasons. It is for practical reasons that you abstract something as relevant and something as too remote. If I today sneeze here and something falls in my house, or if I drop something in my house, and because of that dropping, because of the noise, somebody who is sleeping and is not well gets more unwell, can I foresee that? No, I cannot. So that is too remote a thing that happens. Now, remote and proximate damage. How and where is such a line to be drawn? To answer this question, we are to see whether the damage is too remote a consequence of the wrongful act or not. If that is too remote, the defendant is not liable. Now, what do you mean by too remote? If it is too distant a thing that could have happened. If, on the other hand, the act and the consequences are so connected, they are not too remote but are proximate, the defendant will be held liable. So if something is not too remote or too far, you will be held liable. It is not necessary that the event which is immediately connected with the consequence is proximate and that further from it is too remote. So immediate connected need not be proximate and too further may not be remote. It depends on the facts and circumstances of each case. Now, Haynes versus Hardwood is a case where we'll understand what is immediate and what is remote. In this case, the defendant's servant negligently left a horse van unattended in a crowded street. Now, it is obvious that if there is a horse van, it has to be left attended. Somebody should be there to take care of the horses. And if it is a crowded street, even more liability. The throwing of stones at the horses by a child made them bolt, and the policeman was injured in an attempt to stop them with a view to rescuing the women and children on the road. Now you understand that if you leave horses unattended, children might disturb them. Okay. One of the defenses pleaded by the defendant was novus actus intervenus, or that remoteness of the consequences. That is, there was some other act which intervened the consequences. That is, the mischief of the children was the proximate cause, and the negligence of the defendant's servant was the remote cause. So he said that had the children not disturbed the horses, they would not have been liable. It was not the problem that the servant left the horse unattended. It was a problem that the children disturbed the horse. Okay. It was held that the defendant was liable even though the horses had bolted when children threw stones at them, because such a mischief on the part of the children was anticipated. So the court held that you should have anticipated that if there are children around, they might disturb the horse or they might trouble the horse. So you are liable. The court said it is not true to say that where the plaintiff has suffered damage occasioned by a combination of wrongful act of the defendant and some further conscious act by an intervening person, that of itself prevents the court from coming to the conclusion in the plaintiff's favor if the accident was the natural and probable consequence of the wrongful act. So the court said just because somebody else intervened and caused something does not absolve the plaintiff from the liability. This was a natural and immediate probable consequence of your wrongful act. What wrongful act? That you should have not left your horses unattended. Because you left your horses unattended, that is why somebody bolted. That is why somebody threw stones. Had you been standing there, nobody would have thrown stones at your horses. And hence you are liable. This is not too remote. This is a natural and probable consequence. Now, there are two tests to determine whether something is remote or not. The test of reasonable foresight and the test of directness. Now, earlier the test of reasonable foresight was considered to be relevant. Then this was discarded and the test of directness came into picture. But as of now, the test of directness is discarded and the test of reasonable foresight is considered to be the correct one now. According to this test, if the consequence of a wrongful act could have been foreseen by a reasonable man, they are not too remote. So if you can foresee something like this happening, like in the last case, if you leave your horse unattended, you can foresee that they might harm somebody, correct? If on the other hand, a reasonable man would not have foreseen the consequences, they are too remote. So if you cannot foresee something, they are remote. If you can foresee, they are not remote. This was the test of reasonable foresight. As per this test, if I commit a wrong, I will be liable only for those consequences which I could foresee. For whatever could not have been foreseen is too remote a consequence of my wrongful act. So if I cannot foresee something, I am not liable. It is too remote. Now, this test of directness is the second test. The test of reasonable foresight was rejected and the test of directness was considered to be more appropriate by the Court of Appeals in Re Polymus. Okay, now what is this test of directness? According to the test of directness, a person is liable for all direct consequences of his wrongful act, whether you could have foreseen them or not, because consequences which directly follow a wrongful act are not too remote. So in the first example that we see, that somebody hit a pedestrian who was carrying a bomb, and then the building also got fire, and you had some people getting damaged, the person would be liable for all those acts. However, if you see the test of reasonable foresight, nobody could have foreseen that somebody is carrying a bomb in their pocket and then it falls and then so many people get injured and then the building catches fire. That is not a reasonable foresight which somebody would have. As per the test of directness, you will be liable. But as per the test of reasonable foresight, you will not be liable. Now, the only question which has to be seen in such a case is whether the defendant's act is wrongful or not. That is, he could foresee some damage. If it is wrong, you are liable for all that directly occurs. So, the answer is, if the answer to this question is the affirmative, that is, if he could foresee any damage if he could foresee to the plaintiff, then he is liable not merely for the consequences which could have foreseen, but for all the direct consequences of his wrongful act. So here the ambit is very large. The ambit of liabilities become very big. Now, the first authority for the view advocating the test of directness is Smith versus London and South Western Railway Company. Now, here what was held? Where there is no direct evidence of negligence, the question what a reasonable man might foresee is of importance in considering the question whether there is evidence for the injury of a negligence or not. But where it has been once determined that there is evidence of negligence, the person guilty of it is equally liable for its consequences, whether he could foresee them or not. So once it is proved that you are negligent, you are liable for all. If you are not negligent, you are not liable. What the defendant might reasonably anticipate is only material with reference to the question whether the defendant was negligent or not, and cannot alter the liability if they were guilty of negligence. So what it says is, whether you could foresee or not is responsible for negligence. Once it's proved you are negligent, all the direct consequences which have happened because of your negligence, you will be liable. Repolymus. What had happened? In this case, the defendant chartered a ship. The cargo to be carried by them included certain quantity of benzene and petrol in tins. So they were inflammable things. Now, due to a leak in those tins, the contents of those tins collected in the hold of the ship. So there was some leak in those tins and some material got collected. Owing to the negligence of the defendant servant, a plank fell onto the hold and a spark was caused, and consequently there was fire and the whole ship got destroyed. Okay, so what happened? You were carrying some petrol inflammables and some of it leaked, it got collected somewhere. Now a spark happened because of the defendant's negligence and the whole ship got destroyed. The owners of the ship were held entitled to recover the loss, nearly 2 lakh pounds, being the direct consequence of the wrongful act, although such a loss could not have been reasonably foreseen. According to Lord Justice Scruton, it was held to determine whether an act is negligent, it is relevant whether any reasonable person could have foreseen the damage of the act. If he would not, the act is not negligent. But if the act would or might probably cause damage, the fact that the damage is in fact caused is not the exact kind of damage which one would expect, is immaterial. So it says if you could foresee that a wrong could happen, the fact that the damage which has happened is not what you could have anticipated is immaterial, so long as the damage is in fact directly traceable to the negligent act. So what it says, what damage you foresee is not relevant. What damage you expect is not relevant. The fact that the damage has happened because of your act is relevant, and not due to the operation of independent causes having no connection with the negligent act, except that they could not avoid its result. So if something has happened independently, that's immaterial. That you have caused a negligent and that damage has happened is relevant. Once the act is negligent, The fact that its operation was not foreseen is immaterial. So once you prove negligence, all the direct acts which happen after it, you are liable. In the present case, it was negligent in discharging cargo to knock down the planks of temporarily staging, for they might easily cause some damage either to the workmen, cargo, or to the ship. So the fact that some damage could have been caused was foreseen, so there was negligence, and this caused problem, and therefore you were liable. The fact that they did directly produce an unexpected result, spark in an atmosphere of petrol vapor which caused a fire, does not relieve the person who was negligent from the damage which his negligent conduct caused. The test of directness, however, was considered to be incorrect and was rejected by the Judicial Committee of Privy Council in Overseas Tank Ship versus Modstock Engineering. This is called the Vagamond case. Right? The Vagamond case has held that the test of reasonable foresight is the better test. That is the test which is applied today also. And practically also, if you can foresee something to happen, then you should be liable. If something keeps happening like dominoes effect, you cannot be liable for all the acts, right? Now, what happened in the Vagamond case? In this case, the Vagamond, an oil-burning vessel was chartered by the appellants Overseas Tank Ship Limited, OTL, we call it, and was taking fuel oil at Sydney Airport. At a distance of 600 feet, the respondent's Mott's Dock Company owned a wharf where the repairs of the ship included some welding operations were going on. Now, because of the negligence of the appellant servant, a large quantity of oil was spilled in the river water. So it came down on the water. The oil which spread over the water was carried to the respondent's wharf. Now remember, they were welding something. After about 60 hours, okay, now this has happened and 60 hours have passed. Molten metal from the respondent's wharf fell on the floating cotton waste, which ignited the fuel on the water, and the fire caused great damage. Now, I had some oil spill that was 600 feet away, some welding was going on. 60 hours after that, some metal fell on cotton, that cotton caught fire because of the oil, and some damage was done. Can you reasonably foresee something like this happening? It was found that the appellants could not foresee the oil so split would catch fire. Obviously, you cannot foresee something like this happening so remote. It is remote, correct? Now, the trial court applied the rule of directness and held the OTL liable. Obviously, you hold liable because you are saying this is a direct consequence of something. The Supreme Court of South Wales also found the polymus rule and the mentioning of unforeseeability of damage by fire was no defense and held the OT Limited liable. Manning Justice said, notwithstanding that, if regard is to be had separately to each individual occurrences in the chain of events that led to this fire, each occurrence was improbable. And in one sense, improbability was heaped upon improbability. So it was improbable, and one after the other, improbable things kept happening. I cannot escape from the conclusion that if the ordinary man in the street had been asked as a matter of common sense, without any detailed analysis of the circumstances, to state the cause of fire, he would unhesitantly have assigned such a cause to the oil spillage by the appellant's employee. So you hold them liable. On appeal to the Privy Council, held that repolymus was no more good law and reversed the decision of the Supreme Court. Since a reasonable man could not foresee such injury, the appellant was not held liable in negligence, even though the servant's negligence was direct cause of the damage. So the rule of reasonable foresight was upheld. Referring to the above judgment of the Supreme Court, the application for the repolymus rule there, the Privy Council held. But with great respect to the full court, this is surely irrelevant, or if it is relevant, only serves to show that the polymus rule works in a very strange way. So it works in a very strange manner. Why? Because you hold somebody liable for anything that keeps happening. After the event, a fool is wise. But it is not the hindsight of a fool. It is the foresight of a reasonable man which alone can determine responsibility. The polymus rule, by substituting direct to reasonable foresight consequences, leads to a conclusion equally illogical and unjust. So, directness was set aside and reasonable foresight was upheld. This is the rule which applies when you apply the case of reasonable foresight. So, remoteness of damage, the test is reasonable foresight. If you can reasonably foresee something happening, it is a liability for you. If you cannot see something happening, you are not liable for the wrong.